Here, this is a part 3 of my series of lecture on the topic of interpretation of section 6 of the Hindu Succession Act. So, our discussion on this topic is continuing here. For understanding the proper interpretation of amended section 6 of the Hindu Succession Act, firstly, we must understand the concept of obstructed heritage and unobstructed heritage under the Mitakshara law. Mitakshara divides property into two classes, namely apratibandha daya, that is unobstructed heritage, and sapratibandha daya, that is obstructed heritage. Pratibandha means obstruction. So, unobstructed heritage and obstructed heritage. That means when there is no any obstruction in getting the property rights by of succession, then it is unobstructed heritage. On the contrary, when there is any obstruction in getting the right by of succession, then it is obstructed heritage. The property in which a person acquires an interest by birth is called unobstructed heritage. Person who acquires the interest by his birth, by virtue of his birth, it is called unobstructed heritage, because the acquiral of the right to it is not obstructed by the existence of the owner, existence of the previous owner. Thus, property inherited by a Hindu from his father, from his father's father, from his father's father is unobstructed heritage as regards his own male issues, that is his son, his grandson and great grandson. Means, if a father inherits ancestral property from his father, then the property which comes in the hands of father is ancestral property from the point of view of his own sons. His own son get interest in that property by birth, that is by virtue of his birth in the family. So when the son gets an interest in that ancestral property by birth, it is an unobstructed heritage. So his male issues acquire an interest in it from the moment of their birth. Right? Acquires from the moment, and why? Because of birth. Their right to it arises from the mere fact of their birth in the family, and they become co-partners with their paternal ancestor in such property immediately on their birth. And in such cases, ancestral property is unobstructed heritage. It means that it is not necessary for that son that his father should die. His father should die, then only he will get the interest in the property. Not necessary. Means in case of unobstructed heritage, it do not depends upon the death of any ancestor, but this right occurs by virtue of birth in the family. Now, what is then obstructed heritage? Property, the right to which occurs not by birth, but on the death of last owner. Is called obstructed heritage. It is called obstructed because the accrual of right to it is obstructed by the existence of the owner. Suppose a person who is in employment doing a job, he is getting a salary. From his salary, he saves the money, and from that money, he buys some land property. Then in that case, such land property is his self-acquired property. Then in that self-acquired property, his son will not get any interest until his father is alive. Means from the point of view of his son, for getting the interest in that land property, there is one obstruction. An obstruction is that his father is still alive. So in case of obstructed heritage, in case of separate property, that son will get interest in the property of his father only upon the death of his father. Thus the property which devolves upon the death of the last owner is obstructed heritage. Means property which devolves upon the son after the death of father is the obstructed heritage. That son do not take vested interest in the property merely by reason of his birth. His right to it arises for the first time on the death of the last owner, that is his father. And until the death of his father, he is having mere space successionist. That means he is having a mere or bare chance to get that property by of succession upon the death of his father. As per the Mittakshara law, an obstructed heritage devolves by survivorship, whereas obstructed heritage by succession. Unobstructed heritage devolves by survivorship. Survivorship means, suppose in a joint Hindu family there are four brothers. They are having coparcenary property, that is ancestral property. Suppose one of those four brothers died, then undivided interest, undivided share of that deceased brother will devolve upon other three surviving brothers by rule of survivorship. That is called survivorship. So, property in the nature of unobstructed heritage devolve by rule of survivorship, and property in the nature of obstructed heritage, it devolves by of succession, that is by of inheritance. Means, suppose in the last example, that father has acquired a land property which is his self-acquired property. Then, in case of that land property, when father dies without making any will, then that land property will pass on to his son by way of inheritance. Thus, in case of separate property, that is in case of obstructed heritage, property will pass on by inheritance, that is intestate succession, or if suppose father makes will, then as per the will. If suppose the father make a will, then as per the will, then it will devolve as per the testamentary succession. Thus it is apparent that an obstructed heritage takes place by birth, by virtue of birth, by reason of birth. And the obstructed heritage take place after the death of the owner. Unobstructed heritage by birth, obstructed heritage after the death of the owner. We are discussing the topic of proper interpretation of section 6 of the Hindu Succession Act as amended by amendment of 2005 Act. So here it is significant to note that the right which is recognized under section 6 is the right by birth, right by virtue of birth, and so it is an unobstructed heritage. Here it is not the obstructed heritage depending upon the owner's death. So it is not obstructed heritage depending upon the owner's death. Therefore, the co-partner father need not be alive on the 9th September 2005, which is the date of substitution of new section 6. Therefore, the co-partner father need not be alive on the 9th September 2005 for the accrual of rights in favor of his son or daughter co-partner. Why this point is important? Because in that earlier cases of Prakash versus Fuloti and that Dhanamma versus Amar and Mangamal versus T.V. Raju. In those previous cases, the division bench of the Supreme Court held that for getting the right to a daughter in the ancestral property, for getting a right as a co-partner in the ancestral property of his father to any daughter, his father must be alive on the 9th September 2005. Then only that daughter will get interest in that property. So on this background, it is necessary to remember, it is necessary to understand that the right in case of ancestral property is in the nature of unobstructed heritage, and that accrual of right does not depend upon the death of father co-partner. Therefore, it is not necessary either for formation of a coparcenary or for becoming a coparcener that a predecessor coparcener should be alive. It means that in a joint Hindu family, for a son to become a coparcener, it is not necessary that his predecessor should be died. For his becoming the co-partner in the family, it do not depends upon the death of predecessor co-partner. Why he become a co-partner in the family? By virtue of his birth. Here, death of predecessor co-partner is not relevant, but the birth within 3 degrees or generation from the common ancestor, that is relevant. Birth within the 3 degrees in that family, 3 generations, that is relevant for becoming a co-partner and getting the right in the co-partner property, because right gets in the co-partner property from the moment of birth by virtue of the birth. So, in the amended substituted new section 6 of the Hindu Succession Act, if we read the clause A of subsection 1 of section 6, it makes daughter by birth a co-partner in her own right and in the same manner as the son. So, this new provision makes a daughter by birth a co-partner in her own right and in the same manner as his son. Therefore, this section 6 subsection 1 clause A contains the concept of unobstructed heritage of Mittakshara coparcenary, which is by virtue of birth. Then next, clause B of subsection 1 of this section 6 confers the same rights in the coparcenary property as she would have had if she had been a son. That means, if suppose If suppose said daughter, if she had taken a birth as a son, then the right which she would have got as a son, the same rights now she will get here. So this section 6 subsection 1 clause B confers the same rights in the coparcenary property to a daughter as she would have had if she had been a son. Even though the rights can be claimed with effect from 9 September 2005, these amended provisions are of retroactive application, because they confer benefits which are based on the antecedent previous event. What is that event? Event of birth of that daughter in the family. So why she got a right? Because of that antecedent event. But she can claim that right with effect from 9 September 2005. Thus it is not at all necessary that father of the daughter should be alive, should be living as on the date of the commencement, as on the date of the commencement of the Amendment Act, as she has not been conferred the right of coparcenary by obstructed heritage. So father of such a daughter need not be alive on the date of amendment, that is 9 September 2005. That means even though father has died previously, then also daughter will have right in the coparcenary property of her father, because such daughter is not getting right in the nature of obstructed heritage. Her right is not depending upon the death of her father. The daughter will step into the coparcenary as that of a son by taking birth either before the Amendment Act or after the Amendment Act. It is not relevant. But she is getting right because of birth. However, daughter born before can claim these rights only with effect from the date of amendment, that is 9 September 2005. But she can claim right subject to saving of past transaction as provided in the proviso clause to subsection 1 of section 6. Read with subsection 5 of section 6. Means what are those exceptions? If suppose the property is already partitioned as per the previous law, then daughter will not have right to claim partition again from afterwards 9 September 2005. So these proviso to subsection 1 of section 6 and subsection 5 to section 6 saves all previous valid transaction with respect to coparcenary property. If there had been already partition before the 9 September 2005, then coparcenary is not in existence on the date of 9 September 2005. Therefore, daughter will not claim her coparcenary right of partition again. Therefore, the coparcenary must exist and coparcenary property must exist on the 9 September 2005 to enable the daughter of coparcener to enjoy the rights conferred on her as a coparcener. Thus, the conferral of those rights of the daughter on the daughter is not based on the death of a father, or it is not based upon the death of any other co-partner. So one more thing is that in case of unobstructed heritage, the property devolved by survivorship. Therefore, survivorship is the mode of succession and not that of the formation of coparcenary. So, the rule of survivorship is not the base for the formation of coparcenary. It is a just mode of succession. But this mode of succession, survivorship as a mode of succession of property of Mithakshara coparcenary has been abrogated with effect from 9 September 2005 by the provision of subsection 3 of section 3. Means after the amendment, even this mode of succession, that is survivorship as a mode of succession, now do not exist.